As this year's Supreme Court session comes to an end, we ask, how will the recent rulings affect each and every one of us living in the Gulf Coast region? The High Court has handed down opinions on handgun laws and the right to bear arms, juvenile sentencing and life without parole, and the freedom of speech versus freedom of religion, plus immigration, animal cruelty, and the restriction on corporate speech. Tonight, the Supreme Court and you. I'm Ernie Manous, and this is Houston 8. The Supreme Court of the United States is the highest judicial body in the land. It consists of 9 justices. As a seat becomes available, the new justice is nominated by the President and must be confirmed by the Senate. Once appointed, justices effectively have life tenure, which terminates only upon death, resignation, retirement, or through impeachment. Most cases are decided in lower courts. However, if a party is not satisfied with the ruling, they may appeal to a higher court, with the possibility of eventually working their way up to the Supreme Court. In one term, approximately 10,000 petitions are filed, of which only 1 to 2% are ever heard. Should the case reach the High Court, attorneys from each party are given 30 minutes to make their appeal through oral testimonies. This hearing is not a retrial of the original case, nor does the court re-examine the original evidence. By the end of the term, the justices' decisions are announced. These decisions are based on the constitutionality of the issue. Once a majority decision is announced, it becomes the law of the land and must be upheld in all the lower courts, affecting the lives and liberties of all people residing within these United States. Joining us tonight are Dr. Leslie Griffin, Larry and Joanne Doherty, Chair in Legal Ethics, University of Houston Law Center. Charles Rocky Rhodes, Professor of Law, South Texas College of Law. And Aaron Streett, Appellate Lawyer, Baker Botts L.L.P. Welcome to all of you.
Thank you.
Good session, bad session? How do we rate this go-round with the Supreme Court?
Pretty good session. The court was unanimous in more decisions than usual. And the court certainly decided enough blockbusters to keep us interested and to keep the lower courts in line, as they always do.
Leslie, when Aaron says more unanimous decisions, is that a good thing or a bad thing, do you think?
I think it can be a good thing for the country because it conveys an impression that there's a rule of law that isn't partisan, something we always hope for from the courts, that you can really go to courts and hope your decision won't depend on which president appointed a justice or which party a justice belongs to, but that there really are principles of law that everyone can agree to.
And Rocky, how soon after these hearings the decisions are made, does it affect our lives? How quickly?
Well, sometimes it can be immediately. When you look at something like the Citizens United election case, immediately that's going to start making differences with respect to how we approach elections.
You know, since you mentioned, let's just start right there. Citizens United, that was the big campaign finance question that was out there. It got a lot of run during the State of the Union with the president responding and the justice responding back. Who wants to take that and explain a little bit about what we're talking about in this particular case? I'm going to start with Aaron, since you almost look like you were about to speak on it.
Well, the question was whether corporations have the same free speech rights as individuals to run political ads during campaign seasons that mention particular candidates.
And if I understand also, it had to do with the support coming from the general operating fund as opposed to monies raised outside of that?
That's right. Previously, corporations could create a PAC, a political action committee, for the purpose of spending money on campaigns, but this decision allows them to take money out of their general operating funds.
And so why is this an issue? What is the point that everyone is getting so bothered about? Is it that we are treating corporations as individuals, or am I missing the point?
Well, I think it's a little bit of a misimpression. I don't think it's true that General Electric or General Motors is going to begin running campaign ads because their shareholders wouldn't let them get away with it. To me, this decision was about nonprofit corporations, which includes the ACLU, the NRA, unions, all kinds of groups on either side of the issue. And to me, that's what this decision was about. It wasn't about big corporations running ads.
And Leslie, what was decided?
Well, I think the concern was that you could get much more access of corporate money into the election system. And so by saying that you didn't have to have the separate PAC system, the idea behind the separate PAC system was always to protect that people who really wanted to contribute to a campaign, that money was going to a candidate, right? And so the idea was, well, let's try to link up the people who want to give to a campaign to a candidate, and not just to make huge amounts of general corporate money available. Now, see, it might be right, as Aaron says, that the corporations don't really want to take all their generally available money and put it on campaigns because it would not serve their business interests. But the fear is about just what those business interests are.
Yeah, Rocky?
And I think that's why one thing that's important about Citizens United that doesn't get a lot of play is that the court did uphold the disclosure requirements. In other words, we have to be able to discern which corporations are spending which money. And if, for instance, let's say General Electric does start spending a lot of its money supporting particular campaign expenditures on behalf of certain politicians, then us as consumers can make decisions, well, maybe I don't want to do business with General Electric anymore because I disagree with how they're taking the profits from my business and what they're doing with it with respect to
political
Aaron
mentions nonprofits also. So if, and I'm trying to work my way through this, if the ACLU, for example, decides that they like a candidate, now are we talking about at any level in politics, or does it have to be at a national or state level? I mean, if they decide there is a city rep in a city and they want to pump a whole lot of money into that, can they do that? Is there total freedom?
Yeah, now with the first, they can as long as it's their independent expenditures, which means that they can't just give that money to that candidate. They have to run their own ads and say that this ad is paid for by the ACLU. And then, yes, they can.
So let's call them nonprofit organization X. Nonprofit organization X likes candidate Y, runs all these ad campaigns. They can, especially on a local level, can so outspend anything raised locally. Doesn't that throw off the balance of what's fair?
Well, one thing to keep in mind is that about half of the states already allowed corporations and labor unions to do this, and there really hadn't been any evidence that this had really distorted the election process in the way that we're sometimes hearing that might happen. And it goes back to, I think, what Aaron says, is that as a reality, corporations typically don't do this. And then when you're talking about the nonprofits, they don't have necessarily the millions and millions of dollars to spend in the same ways that the larger corporations do.
I would worry, though, that the ones that do are the ones that want the power that they can get. There's a handful of them I can think of right off the top of my head that are the nonprofits that are just have the money to do these things. So I'm just concerned. But if you're saying that it's already been around in a lot of different states already, so basically the Supreme Court was just saying this can work on the national level?
Well, I think the one important thing that Justice O'Connor, who was no longer on the court when Citizens United was decided and who had voted for some of the precedents that the court overruled in Citizens United, was very concerned about judicial elections, saying everybody is focused on the other elections, but that for judicial elections to pump a lot of money into judicial elections could be a big concern. And so she was worried about the impact that loosening this money might have on the judiciary.
And Aaron, remind us, what was the president's concern with this that got everyone riled up?
Well, he expressed similar concerns to what you've expressed, that for-profit corporations would come in and spend money in elections. And I think he left the misimpression that Rocky corrected, which is that this did not allow corporate donations to candidates' campaigns. It allowed corporations, including nonprofits, to spend money independently, not coordinating at all with the candidate. And a lot of times candidates don't like it when these nonprofits come in and issue a message that's different or differently framed from the way the candidate would put it.
Bigger picture, and we step back then, does this start then to treat corporations legally as individuals? Is there any concern about that?
Well, there's a lot of areas in law which we've already started down that path, and so it's really not that surprising that here too that this court found that the corporations have, in some respects, similar rights, although, there are some areas in which a corporation is still going to be treated differently than a natural individual person.
Leslie, I'll let you have the last word on this.
I think the bigger issue behind the ruling was that there were narrower grounds by which the court could have decided the case. It was about the Hillary the movie, a video on demand, and they could have made a narrow statutory ruling.
Real quick, so people know Hillary the movie, what are we talking about?
So that was the video that was challenged. Citizens United said they wanted to show Hillary the movie before the election, and they went to court to find out if they could show it or if they would fall over the campaign finance laws. So it was Hillary the movie during the presidential election campaign that got everybody into court because people were uncertain, right? But that's part of why you need the court to settle the law. People
and that
were
shows
uncertain.
the difference about an organization creating their own image of how they want to promote, and do they have a right to do that? And the Supreme Court says that they do, basically, is where we leave that one. I want to go on to another one. One that caught our attention, and which is why we're even doing this show today, was McDonald versus Chicago. So who wants to start off on that one?
Well, I can start off on that one a little bit. I mean, Chicago essentially banned any person from being able to possess a handgun in their home.
And that ban was effective in reducing crime in the city of Chicago.
At least that's their evidence.
Their statistics said that.
There are some statistics that say that. Other people would disagree with those statistics. Of course, that goes back to the statistics. Everybody had their own statistics on what is the effectiveness of that ban. And because there was other evidence that showed that the murder rate had gone up in Chicago during this period of time. And other people had said, well, that would have gone up more. So there was a lot of different arguments about statistically how much that helped.
And I bring that part up because, as we said in the setup piece, the Supreme Court, as I understand it, is not to be looking at the effectiveness of how this ban was working or not working, but the constitutionality of having the ban, correct?
Well, exactly right. I mean, the concern was, did this violate the right to self-defense that's protected by the Second Amendment's right to keep and bear arms, that essentially that the United States Supreme Court had originally announced just a couple of years ago.
Now you say right to self-defense and right to bear arms.
Yeah, I actually probably didn't say that exactly the way I meant to.
Because there's a point in it where they talk about the right to bear arms became the right to possess handguns. And that is not what the Second Amendment says. The Second Amendment says the right to bear arms.
It says right to keep and bear arms.
Keep and bear arms. So then it became a question of the historic implication of what that means.
Right. And what the court has found is that idea of a right to keep and bear arms includes a right to have weapons for self-defensive purposes.
So now when something like that is ruled, is that a new interpretation of the Second Amendment that then is applied henceforth?
Well, the question really hadn't come up specifically in front of the court before. It's an amazing thing that this aspect of the Constitution, there had been a couple of side issues decided in the 30s and some back in the 1870s, but they really hadn't squarely addressed this particular issue before.
Leslie, you look like you wanted to say something.
Well, I was thinking when they interpreted the Second Amendment, so it was 2 years ago in the Heller case that came out of the District of Columbia that the court said that the Second Amendment does protect an individual right. Before that, we had
an individual right to what?
Well, I mean, the constitutional language is bear arms. I read McDonald to say that there's a right to self-defense in the home.
Okay.
Because the cases that came up were based on facts in the home, and there's a lot of emphasis in the opinions on the right to self-defense in the home.
So then what does McDonald do?
So what McDonald does is it says that individuals have some Second Amendment right, and lawyers will now argue. So I'll say McDonald says that there's a Second Amendment right to self-defense in the home, but not a broad right to bear arms. But what will be happening is we'll be arguing about just how far the right goes.
Aaron?
Well, I think McDonald also was about whether the right to bear arms could restricted the states and localities as well as the federal government, because Heller only pertained to the District of Columbia. That was the previous Second Amendment decision. So this case was about whether the right to bear arms was fundamental enough that it should also restrict the states and localities in their ability to regulate firearms. And so you had a great debate within the court of how fundamental the right to bear arms was. Is it as fundamental as the right to free speech or the right to a jury trial? And you had 5 justices saying that it was, and you had 4 saying that it wasn't. And one reason they said that it wasn't is because handguns are ambiguous in their relation to liberty. Sometimes they take away liberty, sometimes they help protect your liberty. So that's where some of the statistical analysis came into the constitutional angle on things.
Okay, and since you bring it up, and in my research, this will show you how little I know of the law, so please help me through this, that the Bill of Rights applies federally, applies to the nation, and that this helps define that the Bill of Rights or just the Second Amendment now can apply locally?
Well, the Founding Fathers, when they made the Bill of Rights, they intended it only to apply to the federal government. The reason was that at that time you had the state constitutions were taking care of the states, and so the concern was that this big bad new federal government that was created was going to trample on individual rights. And so the whole original purpose of the Founding Fathers was that the Bill of Rights only applied to the federal government. But Civil War, Reconstruction, concerns about the states and their ability to protect their former African slaves that had just been released led to the 14th Amendment to the United States Constitution, which for the first time explicitly constrained states and said that no state shall deny people rights like equal protection and due process and the privileges or immunities of United States citizenship. And that has been the vehicle for what Aaron was talking about these fundamental rights. If it's considered to be a fundamental right, then it can be part of these concepts of due process, or according to Justice Thomas, privileges or immunities, that then bind the states as well as the federal government.
Will we see that come around again should marriage rights make it to the Supreme Court, where states might choose one way or another and the federal government might choose an overlying definition? Would we see this then addressed there, do you think?
It wouldn't come up in exactly the same form because it's not talking about an individual right as much as that issue would come up under the guise of equal protection. And there's no doubt that the 14th Amendment requires the states to provide equal protection to all of its citizens. So the question would be squarely before the court whether states deny equal protection if they allow marriage to some and not to others.
Okay, but that is not currently in front of the court, so we'll leave there. Anything else on McDonald we want to do before we move on?
Well, one thing that we're not going to hear the last word. In fact, pretty soon after the decision, about a week ago, Chicago enacted a new ordinance, which is already being challenged right now. The ordinance had some great features of it. It said that you had to have a 1-hour training course, but you couldn't have it anywhere in Chicago because it was illegal. And so that lawsuit's already been filed challenging Chicago's subsequent legislation.
So we haven't heard the last.
We have not heard the last of this.
Because the Supreme Court didn't set a clear standard by which all the lawsuits will now be litigated. We know that the Second Amendment protects a fundamental right, but we don't know yet how that fundamental right is going to be balanced against the government's concerns to protect people. It's what Aaron said about the liberty issue goes both ways, and that means there's going to be a balance between the states trying to regulate consistent with the Supreme Court's ruling that there's a fundamental right.
You mentioned something being vague that comes out of the Supreme Court. Is that an intentional tool that they use, or is it just a miswording along the route? Do they plan to be vague? Is that something they're going at, Aaron?
They are just vague enough to be able to get 5 votes for majority opinion. And that's probably the way it should be, because if the court doesn't decide everything in one decision, then it allows the issue to be played out in the lower courts, and it can get a variety of views from lower courts across the spectrum in different parts of the country with different judges, and then it can decide the next issue the next time it comes up to the Supreme Court. So I think it's part of the judges trying not to make law and trying instead to decide cases, trying not to legislate but to adjudicate.
When the Supreme Court justices make a decision, do they do it independently of each other, or do they do it together as a group? Is there a discussion that goes on among the justices and they argue out where they're at, or are they each off in their own area and decide what they believe?
Well, right after the oral argument takes place, the justices meet in a conference room with nobody else in the room except for the justices, and they cast their vote on the case. And then the opinion writing process starts. One justice starts to write the opinion for whatever position got the majority. And then that justice circulates the opinion, and once it has 5 votes, then that is going to be the majority opinion. Then dissenting opinions are written, and when that's all done, then the decision is released. So it's a collaborative process, but there's always one justice writing the majority opinion.
Okay. Next case we want to hit on before we run out of time, and it's close to home. We call it the Skilling case, but it actually has to do with corporate fraud case, I guess, is a better terminology for it. Who wants to start me off on that one? Leslie, I'll let you begin with
there
Skilling.
were 2 issues in the Skilling case, and one, of course, was that there was the statute called the Honest Services Statute, and that wasn't unique to the Skilling case. There was a statute that said prosecutors could prosecute somebody for not providing honest services in a corporation. And so the prosecutors had been using that, and the court took numerous cases on that and said that the statute was too vague, that it could, and that they had to limit the statute because prosecutors were using it too broadly.
And just to clarify, too, the Skilling case is Enron. That's
Enron, right.
Jeff Skilling we're talking about. And the honest services, as I understood it, and we talked about this a little bit before we went on air, honest services is if you should make a profit outside of your specific job task, but maybe influenced by what you're doing, as long as there's no bribery. Is that?
Well, the statutory language was honest services, and so what the court said is that because it had been interpreted so broadly, they would restrict it to meaning that the honest services statute could now be used only in cases of bribery and kickbacks.
And since what we're assuming in the Skilling case, there was no bribery or kickbacks, this will probably be tossed out, correct? Is that safe to say?
I don't know, Aaron, do you think it would be?
I think most of a lot of the counts on which Skilling was convicted are probably going to be tossed out now, but some of his other convictions will probably stand.
Now, the bigger issue that affects us right here in Houston that comes out of this same case is, can you get a fair trial here in Houston? How in the world does something like that go to the Supreme Court?
Well, it's funny. I mean, I actually do this. I used to do this with my students. I said, okay, if you're representing somebody in Enron, do you want to be in Houston or do you want to be in New York? And of course, you know, from the defendant's perspective, I'd rather be in New York. I mean, because I wouldn't have had the opportunity of perhaps having somebody on my jury pool who knew somebody who lost their job, lost their life savings, et cetera, et cetera. But, you know, the court in this case took note of the fact that, you know, Houston is a large metropolitan, 4.5 million people community, and you can find 12 jurors, especially with the way that the judge handled this case, who can be fair and impartial.
Is that kind of surprising that we had to go to the Supreme Court to find out we could find fair jurors in Houston?
Well, there had been a number of cases from the Supreme Court that had dealt with murders or other sensational crimes in smaller communities where they said, look, there's no way anybody could have ever had a fair trial in this community under this circumstances. And they said it was a violation of the defendant's due process right. And Skilling had made the similar argument with respect to his trial here.
Okay. I hear that we are running out of time, as we always do on the show, so I want to make sure we hit the CLS case, the Christian Legal Services, is that what they were called?
Christian Legal Society.
Christian Legal Society.
And their deal was that they were on a campus and wanted to just include the people that had like view into their organization. But that Hastings then said, no, you have to include all points of view. Am I summing this up correctly?
They wanted to be an officially recognized student group at Hastings and exclude the people that they didn't want to include. So they said that, for example, they wouldn't allow any practicing homosexuals into their group. And what the Hastings policy said is if you have a student organization, you have to accept all comers. It's a so-called all comers policy. And so you've got to be ready to accept all comers. But a recognized student organization.
They could meet on campus nonetheless.
They could meet on campus on their own nonetheless, but they couldn't be an official Hastings student group.
So what do we find out from the Supreme Court on this?
Well, that the law school could have a policy that required student groups to accept all members. And what made the case difficult is that the court had previously held that groups have the right to exclude certain members if it will detract from the message that the group wants to speak under the First Amendment. And I think this case turned, the reason it was 5-4 is because the 4 dissenters believed that the law school was applying its policy unfairly and was singling out the Christian Legal Society, whereas it didn't single out the Muslim Law Student Society and other groups that also had exclusive policies. And I think they were also motivated by the idea that it just sounds funny to say you have a student group that's based around a religion or, you know, the Women's Law Center that would have to accept people who don't believe women should be able to practice law. It just strikes one as a little bit absurd, and that's why the vote was so close.
Although the parties had stipulated before that under this policy that a Republican student organization would have to admit a Democrat, which was an absurd policy. I mean,
right, on the surface, I would have thought, of course, you have to include everyone. But when I started reading more about this case, and I started to think, but the point of having a group is because a collection of like-minded people want to come together and meet, and therefore you're saying you need to add people that aren't of a like mind to your organization for you to be sanctioned.
Well, but the core issue is that on the other side of the equation are all the anti-discrimination laws that we have, right? That the state is saying, well, we have laws that prohibit discrimination on the basis of race, on the basis of sexual orientation, on the basis of religion, and so it's
Does
the
it have
interaction.
to be a protected class,
It's
then?
the interaction between the anti-discrimination laws and the student groups that
But
made
it does
the
have to be
case.
one of those
So-
protected classes? I mean,
I
if you
think
had a
Hastings-
vegetarian organization and you're a meat eater that wants to join it, does it also cover you?
Well, I think that we'll have cases in the future working out the limits. What Hastings argued is that under California law, you had all these anti-discrimination statutes, and that's where the hard issues are between official recognition or funding for groups that discriminate. You know, how do you strike the balance between the government's important need to enforce the anti-discrimination laws, right, and not to foster a group that discriminates?
And there's no question that a group has the right to discriminate as long as they're just doing their own private aspects of their group. The question here is, does the government have to give sanction, essentially, to that discrimination by saying that we're going to give you part of the money from the student fees, we're going to give you an opportunity to use the Hastings logo, et cetera, et cetera.
So if they want to be a private, off to their own, they can do it. There's another point that came up, common carrier versus all comers, being that an airline has certain regulations that's different from an organization or a group.
Well, that's really the question going forward, because previously the Supreme Court had held that the Boy Scouts couldn't be required to have a homosexual scoutmaster, even though they were a wholly private group.
Right.
The state of New Jersey in that case had said that we're calling them a public
accommodations. As in the Supreme Court, our 30 minutes is up, so I have to stop us right there. I'm sorry we didn't get to all the cases, but thank you all for coming in. A very interesting discussion. Now, each week, we invite you to visit our home online at HoustonPBS.org. Simply click on the local programs bar, pick Houston 8, and you can join our online community. Read about the guests, learn more about the topic, share your thoughts and ideas, and even suggest questions that we might ask during upcoming episodes. Remember, information posted on our website may be used on air, so keep that in mind when submitting. That does it for us tonight. Until next time, I'm Ernie Manous. Have a good week.